The public's expectations are high, as are at times their demands. We live in a society where people want to know, and they feel they are entitled to know. Hello, I'm Marcella Lee, and I will be your host for this post-telecourse on specifics of the California Public Records Act.
Hi, can I help you?
Yeah, I'm trying to get some information on some property that I own. It's at 1350 Willow Pass Road.
What kind of information would you like?
Well, I'm the landlord. I own the house there, and I've got some tenants there, and I understand there was some sort of police action there in the last week or two, and I'm trying to find out what went on there.
Are you living in the house?
No, I don't live in the house. I own the house.
Okay. I can't give you that information. If you do not live in the house and you're not involved in the activity that was going on there, I can't give you that kind of information.
Well, maybe you didn't understand what I said. I own the house. It's my house, and I've got to rent it out to some people, and I want to find out what's going on there because the neighbors are complaining, and I lived in that neighborhood for a long time before I moved out, and if there's a problem, I want to get these people out of there.
Yes, I understand. However, I can't give you that kind of information.
Why can't I get the information? It's my house. I'm the one who pays the property taxes on the house.
I do
so
understand
why can't I get it?
But you don't live in the house and you weren't
But it's my
involved in
house.
incidents. But you don't live in the house and you weren't involved in the incidences. So by law, I can't give you that information. It's
well, I pay the taxes
confidential.
on the house. It's my house.
Usually when someone comes into the department wanting information or reports, they expect they can have whatever they want. We are constantly being told, well, it's a public record. Everything's a public record. And then we have to explain to them, well, actually not everything is a public record. We need to look at your request, see what it is that you're asking for, and if you're entitled to that information, and whatever you're entitled to, we will gladly give you.
It's a very difficult thing to do because of the public expectation that a report is always taken when an officer goes out. One of the first things I instruct my staff on is that they really cannot speak for the officer because the officer is the individual who had the discretion to make that decision. So that is first and foremost what we will tell the public when they expect a report and there isn't one there for them. We will see if the officer is available to speak with them at the time they're in our building.
There's a perception that the information absolutely has to be given right then and there on the spot. And the Public Records Act doesn't say that you just have to turn around and give it to somebody right then and there. And sometimes that just stops the employee that's responsible for releasing that information. It just stops them right then and there in their tracks, that when they're faced with someone who is making a demand on them, whether it's over the counter or whether it's on the phone, sometimes they just freeze. Some members of the public, I think, are more savvy than others. So the ones who take the time to actually look up the Public Records Act sections have that expectation, and they write it into their request that please respond to me within 10 days of my request, and here is my request. Others who don't know that can be a little bit more demanding of the, here's my request for this information, give it to me now, and they can present their request that way. Either way, it is our responsibility to let them know and inform them, here is the information that we have available to you right now, and we do need to be responsive to their requests and give them whatever information we have right then and there.
People will come in if they've been involved in a call for service, if an officer has been to their house or to wherever they are. They will come in with the expectation that there should be this big, long 5-page report written on the subject when it might be what is just called an incident, which there won't be a real report written. It will just document the facts, and that's basically it. People will come in thinking that there should have been a big report on it, and everything is always important to that person, and which is rightfully so. If your car gets stolen, you're going to want the police out there looking for it right then and now, when in actuality there's no way they can do that in most departments because of the volume of vehicles that are stolen. But it's important to that person that they feel, I don't know if it's important, or that they were the victim of something and they want something done about it.
As far as the education of the general public, that's not necessarily, I think, they're not necessarily uneducated they may not be as savvy about the Public Records Act, but we, again, need to be responsive and help educate them. And that's, in fact, a part of the Public Records Act as it's written, that it's our job to help them make a focused and specific request. But technology, I think, hasn't really done us any favors as far as law enforcement is concerned. So we just need to try and keep up with it as best we can.
I would say other members of an agency would see the records department as a clerical section. I see it more as a clearinghouse for all the documentation that is done through a police agency. That information is housed in the records section. It's kind of the brains of the department. I try to educate them on what my position is within the department and the importance of my staff's position within the department. But I think as long as they are aware of what goes on and know that there is an ultimate person up there making that decision for the release of information, that it's going to happen through me. Whether they want to consider me a clerk or a supervisor, that's up to them. It doesn't change how I do my job. You know, if it's one of those things that you're going to take personal, you're not going to do your job well.
The California Public Records Act is based on its federal counterpart, the Freedom of Information Act. The two, however, are separate laws. As agency representatives, whether as field officers or record staff, your understanding of the California Public Records Act will help you better serve the public. What is a public record? Who has access to specific reports? Does the CPRA have mandatory disclosure requirements? Are there exemptions? These are questions you should be able to answer, and ones we'll address in this training. In this telecourse, we will look more closely at issues involved with records administration and the CPRA, including defining key terms associated with the California Public Records Act, identifying specifics within the CPRA, such as mandated release, exemptions, juvenile records, including those dealing with child abuse, subpoenas, criminal offender record information or CORI, and liability. The increasing role of electronic record keeping, access authority, who has what access to information, including the public, sworn, city officials, and the media. The role and value of networking with others involved in records administration. Resources available, including training and industry organizations. This telecourse is meant as valuable training for both records personnel and line officers on the importance and specific application of the California Public Records Act.
Records is here to help support everybody in the organization, whether it's the officer in the field, whether it's a command staff level member getting ready to go to a meeting. No matter who it is, we're here to help you. If you need information or you have a question about how to put together something in a crime case that you know is going to be reported to the state, don't hesitate to give us a call.
The front counter can be a very difficult and most stressful position within the records division. You deal with, again, multiple phone calls, people calling you, a lot of foot traffic. And you're the first contact within the department, so you need to be aware of that. When people come in and they're upset, they're unhappy, they have a problem, you're the first person they're going to be dealing with, and so you have to have that mindset and not allow yourself to get sucked into their issues, and you have to remain calm.
You can get any number of personalities at the front counter. You get people demanding things, pounding at the counter, that you get people shouting and yelling at you, calling you all kinds of names, and it's just a matter of being able to maintain diplomacy, basically, because we're all in the public service business and we want our public to be happy. And so it's a balance that you have to try and maintain.
To realize that it is a daunting responsibility, that you are responsible for all this information. You're more than just a clerk. You have to understand laws. You have to be able to interpret laws. You have to make decisions that may not always be popular with either the people you work for or citizens. You have to deal with angry, upset people, It's not always a positive position, but in some ways it's very rewarding.
Step one is, first of all, reading the Public Records Act, which can be found in the Government Code, and knowing then what is required to be released by each law enforcement agency. So that would be the first step, and then finding the best way possible for your agency to make that information available on a regular basis.
I think for any new records technician, the California Public Records Act is an absolute must. They absolutely have to be versed in that, whether it's just the fringes, and they can refer their questions then to supervisors or managers. They need to know who their agency terminal coordinator is, so that those questions that they may have on release issues can be referred to those individuals.
Advice to a new records technician starting out: always keep in mind the citizens do not know your job. Always look at it as if you were on the outsider looking in. You do not know what's going on in there.
Well, it's important that the frontline officers understand how information is given out of the records. So there are ways they can write their reports to help ease that process along for us. In a number of cases, we're not allowed to give out, like if a suspect wants a copy of the report, he may be entitled to it, but under law, we're not allowed to give out victim or witness names and personal information. So if an officer would write a report out using the victim's name everywhere instead of saying victim in the report, we have to go through that report and take out anywhere that victim's name appears. So if it's a 10-page report, we're going to have to read through all that and take out Mary's name everywhere it would show up. So if they just use victim, we wouldn't have to do that report. Kind of helps us out.
It's very critical to have the accurate information to keep up to date on the changes in the laws, in departmental and city policies. It's highly critical.
The central purpose of the California Public Records Act, or CPRA, is to disclose official information that sheds light on the performance of agency duties. Based on the Federal Freedom of Information Act, with application to California records, the fundamental precept of the CPRA is that government records shall be disclosed to the public upon request, unless there is a specific reason not to do so. Most of the reasons for withholding disclosure of a record are set forth in specific exemptions contained in the CPRA. However, some confidentiality provisions are incorporated by reference to other laws. Also, the CPRA provides for a general balancing test by which an agency may withhold records from disclosure if it can establish that the public interest in non-disclosure clearly outweighs the public interest in disclosure. But what is a public record? As defined in law, a public record is any writing containing information relating to the conduct of the public's business, including field reports, including original notes if they have been attached to the report when filed. In short, the public may inspect or obtain a copy of identifiable public records. Writings held by state or local government are public records. A writing includes all forms of recorded information that currently exist or that may exist in the future. The essence of the CPRA is to provide access to information, not merely documents and files. The operative word here is information, which can include handwriting, typewriting, printing, photostatting, photography, imaging systems, email, database information, papers, letters, and any of a long list of current communications formats, including electronic, hard copies, drafts, and notes when submitted. Your individual department training should include examples of these various formats and types of public records. These records, however, are only as good as the original information from which they have been created.
Hi, Lisa. Have a seat.
Hey, Kathy.
Hi.
I was processing this report, getting it ready to go to the DA. And
Okay.
I wanted to show you a couple errors on it.
Okay, what have you found?
The first one is the date.
All right.
It's showing December, and we're still in July.
Yes, we are. Christmas is not here yet.
And the next thing is in the narrative, there's a couple witnesses that are listed here in the narrative, and they're not blocked out on the front of the report, so I think data entry might miss that.
Well, we would have them missing, and the DA would have a hard time finding them in their review of this case as well.
A couple more things.
All right.
The report numbers towards the end of the report change numbers.
Okay, and when we scan that in, it won't be connected with the face sheet.
And one last thing,
All right.
this paragraph right here,
Yes.
it doesn't belong, I think, in this report. The names that are listed here are nowhere listed in this report, and it appears to be a different type of report.
And they're not in any other part of the narrative either?
No, nowhere.
Okay. Well, I'm glad you found this early enough in the morning so that we have time to get it back downstairs so it can be corrected, and we can get it to the DA's office in time this morning. And when this comes back up, then I'll get it to you so we can get it in with the rest of our court packets.
Oh, great. Thank you very much. I appreciate it.
You're welcome. Thank you, Lisa.
Okay, bye.
Bye.
The challenge of dealing with the accuracy of the information we receive is sometimes it's not black and white. It's a lot of gray area that the laws aren't extremely specific, and so there's a lot of interpretation that you have to do as a manager and a supervisor, and even a records clerk has to sometimes interpret the feel of the law as opposed to saying exactly what you need to do, and sometimes that's very frustrating and difficult on the employees.
Oh, there are so many things to start with, but first and foremost, that the information that they gather is accurate, that all of the names that they have the information they've taken from all the people, that the names are spelled correctly, that the addresses are correct on all of the reports that they turn in, because it makes the research work that we do for our routine request, our Public Records Act request, and our subpoenas, it makes our search more accurate and that we give the correct information.
Well, and that's probably one of our hardest jobs, is to get that information out, saying if they can get us the most accurate information, because the officer doesn't see when that person comes in for the police report and they go, well, that's not what I said, or no, this isn't right, this information's wrong, this address is wrong, whatever, and it's something we have to deal with. And so if they get it from the beginning correct, it makes our jobs easier, and it makes for better customer service, because we can get that person in and out and they can be done with, and they can get the information. They don't have to go to the front counter or see an officer and make a supplement and create and put new information on there.
And the more information that is collected out in the field, the more information we're going to be able to provide to detectives and other agencies or anybody else who might be working a crime case.
Customer service is a philosophy in business, meeting or exceeding expectations of those with whom you do business. In records, customer service is also a philosophy, a way of doing business, but it is also mandated by law. Based on the California Public Records Act, Government Code Section 6253.1, revised in 2001, state and local agencies are required to assist the public in making a focused and effective request that reasonably describes an identifiable record, and shall do all of the following: assist in identifying records that are responsive to the request or purpose of the request, and describe information technology and the physical record location in which the record exists. Customer service is satisfied when you treat customers with respect, courtesy, and dignity, clearly identify their needs and help them with their request, and diffuse what could be a difficult situation with friendliness and sincere interest.
Hi.
Hi, good morning. May I help you?
Yes. I'd like to find out what happened at my neighbor's house the other day.
Can you give me a little bit more information?
Well, the police were called out. And
Okay.
I just kind of want to find out what happened.
Okay. Were you at your neighbor's house as well?
Well, okay, let me tell you a story. If I go upstairs in my house and I'm in my bedroom and I look out my window, I can see right into their backyard.
Okay.
So I can see everything that goes on. Well, there was kind of a scuffle, and I saw the police arrive, and I saw them in the backyard.
Okay.
The police pulled up, they came out, so I hurried up and went downstairs and ran around the corner.
Okay. Were you involved in the incident that brought the police to your neighbor's house?
Well, no,
Okay. And did you speak to the police when you went outside?
I did. I flagged one of them down to talk to
Okay.
him to find out if he could tell me a little bit about what was going on.
All right. And what did the officer tell you?
Well, he told me that he was busy handling the call and that I would need to come in and try to get a copy of the report.
Okay. Do you have any involvement in this report other than talking with the officer?
Well, I'm the neighbor. I mean, I live behind them.
Okay. And what is your name?
My name is Lisa
All right. Can you please give me your last name?
Lorton.
All right. And what was the address where the incident occurred?
Well, I don't know. It's the house directly behind me, so it'd be the
Okay.
street behind me, and that, I'd say about the 1200 block of Crestview.
Okay. If you'll wait just a second, I'll check our computer.
Sure.
Well, I see the report is here, but I don't see that your name is listed as an involved party.
Really? Why would that be?
Well, were you actually at the house when the police were called or when they arrived?
Oh,
So
well,
the
I mean,
offi-
I was. I mean, I ran over there.
Well, yes, you did, but it sounds like the officer was already leaving if you talked to him.
Oh, no, there were a bunch
outside.
of them. There was a whole bunch of them there, and I just stopped one of them and talked to him.
Okay. Well, the officer must have thought then that you aren't actually involved with what was going on. So since you're not listed in the report as an involved party, I won't be able to give you a copy of the report. But what I can give you, which is according to the Public Records Act, is a copy of our daily log, and you will be able to look to see what the call for service involved.
Okay.
And so if you want, you can look here and see what was recorded and what the officer's summary was of what took place.
Okay.
And do you see the incident that you're looking for?
Well, yes, I do.
Okay.
But this doesn't really tell me what the police report would say. I mean, I have 2 small children, and we live right behind them. I'm just
Okay.
concerned what happens at that house.
Well, I can understand your concerns, but this is all I'm able to give you at this time. If you have some other concerns about what might be going on, you're able to call and ask an officer to come out and make your concerns known to the officer. But if you would like, what I can do at this time is give you a copy of this daily log, and you'll be able to have that, or else you can take notes from this.
And this is all I can get.
And this is all you can get at this time. So if you'd like, I can make you a copy.
Okay. Well, I'll
Oh.
take a copy.
All right, let me make that for you.
We encourage our employees to treat everyone like they would want to be treated if they went into a government agency. They need to have empathy with a person, but don't be pulled into the anger or the discussion. Try and keep your voice level, low. Explain to them what the issues are and what you can do for them, and as opposed to what you can't do for them. And sometimes that helps.
It's very important because we are the only source for that particular type of service that is provided to the public. So many people, we find, they're either scared that they're coming into a law enforcement agency, or they're very angry depending upon their circumstances. So we are trying to give them the information in the best way possible to help either alleviate their fears or to help calm them down a little bit.
They're human beings just like everybody else, and you just treat them as such. And you go up there and you find out what it is that they need, and you give them the information that they're seeking, either verbally, or explain to them how they can get it, or explain to them what they can and can't have. Then it's really just a matter of regular customer service, whether you're in a law enforcement agency or working as a cashier at Walmart. You know, it's the same sort of thing. You just have to put a smile on your face and go up there and treat them like a human being.
Someone's just going to come in and they're just going to be mean as all get out when they come to the front counter. They're going to be screaming, they're going to be yelling, and it's our job to just diffuse that situation as best we can and just rely on your familiarity with that scenario replaying itself repeatedly.
Hi,
Hi.
can I help you?
Yeah. I'd like to get a copy of a police report.
Okay, what kind of report is it?
I don't know.
You don't know?
No.
Okay, when did it happen? When did it occur?
About 2 days ago.
Okay, that would be Tuesday?
That sounds good.
Okay. And where did this happen?
At our house,
And that would be what address?
4530 Broadway Street, apartment number 2.
Okay. Do you have some identification?
Yeah.
Were there any children involved in this?
No.
Okay. Let me see. I'm going to check our system and see if we have a report. Is that okay? And officers came out to your house?
Unfortunately.
Okay, it looks like we do have a report here
Good.
with you in it. However, I'm afraid at this time I won't be able to give you a copy of it.
Why not?
Well, it's been turned over to the district attorney's office, and there's a waiting period here where we have to wait a few days since they're going to file charges on the report.
But I don't
on
want
the person
them
in the
to
report.
do that. There was nothing that happened. Can
Well,
you get it back?
No. Once a report's taken, the department detectives have.
Look, maybe you don't understand, okay? All she needs
And
is
who
the
are
report.
you, sir? Who are you?
My husband.
Yeah, I'm her husband. Okay, so all we just need is a report. You have her name, you have her address.
And what is your name?
My name is Marco.
Okay. Marco, I need you to
Yes.
have a seat over there.
Look.
Because I'm talking with this lady
No,
here.
well, you're talking to me right now, okay? So all I need is the report.
No, you don't understand. I need you to take a seat
No,
over
I
there
completely
because I'm
understand.
talking to
You
her.
have a report. You typed it in the computer.
I'm not
It's
going
right
to give
there.
you a copy of the report. You need to go have a seat.
We need the report.
Okay. You either take a seat or I will call someone in to help you take a seat. Okay? It's your choice.
Fine. Just fine.
Okay.
Um,
Thank you.
don't I have a right to see the
Yes, you do. Let me give that back to you so we don't lose it. You do, as a victim, have a right to see this report eventually, and we would normally maybe give you a copy of the face page, but due to the fact that we're concerned for your safety at this point, that we're not going to give you a copy of it. And it has been turned over to the district attorney's office, like I said, and once they decide whether or not they're going to file charges on it, then they will contact you. And they'll go over the report with you, but we're going to wait a few days until
she didn't
we
even
find
call
out.
anybody, okay?
Until we find out.
It's true. Nothing.
It's
Okay,
look,
I'm trying to explain to you. I ask you to take a seat, sir.
Look,
Thank you.
it's
Thank you.
jeez.
Okay, let me explain something to you. When we have the report that's filed by the officers, they turn it over to the district attorney's office if they see that there is cause to file charges. It'll be up to the DA whether he files charges or not. They will be in contact with you, and they will let you at that time go over the report.
I need to see it now.
Well, I can't give it to you right now. What I can give you is a copy of this domestic violence form, and you need to take that perhaps and read it.
Look, we don't need this. Come on. Gosh, all you needed to do was just tell them exactly what I told you to say.
We had a domestic violence victim come in with her husband or boyfriend. She was beat up pretty badly, and he was there with her wanting a copy of the report, basically. Through the guise of using her, she didn't speak too many words as he was talking for her, and we had to ask him to sit down so that we could explain to her that while she is the victim, It had just happened within a few days, so it was naturally still under investigation. So that kept us from giving her the report. As a victim, she has a right to the report. However, when you have someone coming in that has been beat up and the person that beat them up is standing next to them, you pretty much know that he's wanting to know what she said about him to get him thrown in jail. And it won't be a pretty sight afterwards. So we were able to not give her the report at that point in time. If someone is requesting a report in that circumstance where we feel it would endanger the victim further, and also with it being still under investigation, we can delay or postpone giving them a report until the danger passes. We don't like to if the victim really we feel is sincere in wanting the report, but when they're standing there shaking in their boots, we pretty much know they're not the one that wants it. They know what they said, and they know why this subject wants the report, to see what she said about them.
Release of domestic violence information to a victim is mandated by statute. The face sheet of the report is required to be released at time of request. However, if you feel that the victim is in imminent danger of release of the entire report, you can withhold releasing the entire report at that time. That can be a judgment call on your front counter staff on what the imminent danger is occurring at that time. Oftentimes, the front counter clerk will consult with supervision prior to making that decision. Eventually, you are going to have to give up the report. Oftentimes, it may be just checking with the district attorney's office to find out when the case is going to trial. After adjudication has occurred, the report may be released at that time.
The right to monitor government is fundamental to the California Public Records Act. In the interest of efficiency and in consideration of the overall purpose of the Records Department, the CPRA is specific about how the disclosure process works. A person need not give notice in order to inspect public records at an agency's office during normal working hours. However, if the records are not readily accessible, or if portions of the records must be redacted in order to protect exempt material, the agency must be given a reasonable period of time to perform these functions. When a copy of a record is requested, the agency shall determine within 10 days whether to comply with the request and shall promptly inform the requester of its decision and the reasons therefor. Where necessary, because either the records or the personnel that need to be consulted regarding the records are not readily available, the initial 10-day period to make a determination may be extended for up to 14 days. If possible, records deemed subject to disclosure should be provided at the time the determination is made. If immediate disclosure is not possible, the agency must provide the records within a reasonable period of time, along with an estimate of the date that the records will be available. In addition, a record may be withheld whenever the public interest in non-disclosure clearly outweighs the public interest in disclosure. We will discuss this in greater detail under the heading of exemptions. To review, what must be disclosed? First, arrest information, assuming no exemption exists, including the full name and occupation of every individual arrested by the agency, adults only. Physical description, date of birth, color of eyes and hair, sex, height and weight, time and date of arrest, time and date of booking, location of the arrest, factual circumstances surrounding the arrest, bail amount, location being held, manner of release, charges upon which being held, warrants and parole, probation holds. Second, calls for service information, including the time, substance, and location of all complaints or requests for assistance, time and nature of the response thereto, time, date, and location of occurrence, time and date of the report, name and age of the victim unless accepted, factual circumstances surrounding the crime or incident, statements not included, general description of any injuries, property, or weapons involved. Review the law because of the many exceptions that exist.
Good morning. How can I help you?
I'd like to pick up a copy of a police report.
Okay, what kind of report is it?
Well, officers came out to my house a couple of nights ago because my ex-husband abused our son.
Okay, so there's a juvenile involved?
Correct, my son.
How old is he?
7.
7, okay. In order to release a report with a juvenile in it, you're going to have to obtain a juvenile court order, and you would get that from the juvenile court.
And why
from
is
the
that?
judge. Anytime a juvenile is involved in a report, if it's for the protection of the juveniles involved, you would have to get a court order.
Okay, well, I'm the parent, and I filed the report, and the officers that responded said that I could come out to the police department and pick up a copy of the report. They actually even wrote down a case number so that I could come down here and pick that up.
Okay, let me see if the report's even in, okay? See if the officer finished it.
That's fine. He said it would be available, though, and I waited a couple of days on purpose because of that.
Okay, it looks like the report is in, and he did complete the report. However, we'll still have to have you obtain a juvenile court order.
Okay, but you have the report here, correct?
Yes, it is in our system.
Okay, well, I'm not going to be going to juvenile court. The officer said that I could come down to the police department and get a copy of that report.
Okay, I understand your frustration with this, being that you are the parent. However, we have laws that are govern us and how we release reports, and I can't give you a copy of it without you bringing in the juvenile court order. But we can't give it to you until
you're
we have
refusing to give me the report.
Well, I'm not going to refuse to give it to you. It's just that you have to follow a process, and that would be to bring
Do you
in
have
a
a
court
supervisor?
order. Yes, I do. Would you like to speak to him?
Yes, I would.
Okay, just be 1 minute, all right? Joe,
Yeah, buddy.
I have a lady in the lobby that's here to pick up a copy of a report with a juvenile in it, and I explained to her that she has to take a petition to the court, get the judge to sign a court order, bring it back to us before we can release the report to her. She is not satisfied with that answer, and she wants to speak to my supervisor.
So she understands that all juvenile records to be released have to be authorized by a juvenile judge?
Oh yes, I went over that with her several times, and I even checked to see if the report was in, and it is in, but I explained to her we can't release it without a juvenile court order. And she still wants to speak to my supervisor.
And she understands that you've got the authority to release that or not, that you don't need your supervisor's approval?
I'm not sure she understands that or wants to understand it. She says she's not leaving until she gets a copy of the report.
Okay, well, let's go up and talk to her.
Okay, thank you. This is my supervisor.
Hi, ma'am, can I help you?
Okay. Did she explain why I'm here, or do I have to explain it all over again?
Well, she explained to me you're trying to get a copy of a report that involves a juvenile.
Correct. Involving my son.
The rules of the court and the rules of the state of California is we can't release juvenile information. We have to get approval from the court to do that.
I don't care about any rules of the court or whatever it is you're preaching. The officer said that I could come down here and pick up a copy of the report.
Well, you can normally pick up the report, but anything that involves a juvenile, we protect that information, and it really doesn't matter who's requesting it. All we can do for you is we can send a request to the court, and the judge has to approve or deny if you can get that report.
I'm not filling out a form. I'm not going to court. The officer said that I could come down. She even said that you guys have a copy of the report that's ready to go right here today.
Well, it is here. I can't release it to you. Like I said, we can give you this form, and then you can take this to the court, and the court will then send you a copy of the report. That's all I can do for you today.
I don't care. I'm telling you that I'm not going to leave without a copy of that report.
Ma'am, I only have two options. You can fill out the petition, take it to the court, get it approved, and then come back here and we'll give you a copy of the police report, or I can have an officer escort you out of the building.
You know what? This is ridiculous.
On juveniles, they are a protected class, so to speak. You have to, if you want to get a copy of a report with a juvenile in the report, you would have to get a juvenile court order from the judge, juvenile judge. You petition for that. Some departments will give you the petition. Others you have to obtain it from the juvenile court. But you have to petition to get the information released. It's not automatically given to you. If a parent comes in to obtain a copy of a police report where their child is a victim, say, of something, they would, depending on the type of case that it is, if it's a sexual case or an abuse case, they would have to petition the court to get a copy of that report. If it is still under investigation, if it's still going through the court process, they still would not be able to get a copy of it at that time. If the school wants a copy of a report where a juvenile has been involved for vandalism, say, there is only one person in the school district that would be able to get a copy of that report. They would get the copy if it's not still under investigation by the department. Usually they work together because the school has their own punishments aside from what the department would charge them with. So it's not black and white. If a request is made for juvenile records, the records personnel should immediately let the person know that more than likely they're going to have to petition the court to get a copy of the report. They will then go and look for the report and probably bring it to the supervisor to make sure that there's not something else going on in the report aside from just that juvenile.
Information that can be released about a juvenile varies county by county and is dependent upon the individual standing county TNG order. Review of the TNG order, including whether juvenile court review or waiver is part of the order and what impact multiple juveniles may have on the release of information, should be a specific part of departmental training and periodic update.
Well, for a child abuse case or sexual abuse case, anything involving a child, there's a specific statute that's put into place to protect that child. A parent, because they're that child's parent, they think they're entitled to everything associated with that child or with that report. So often you'll have a parent come in where the child abuse report was against the other parent or a step parent that still happens to live with that child, and they come in and they want a copy of that report, and you have to tell them that they can't have it because there's a statute in place or law in place that states, we're sorry, we can't give this to you. It can only go to the district attorney or another law enforcement agency or Child Protective Services because they're the ones protecting that child. And a parent often has a very difficult time hearing that they can't have access to that report. So it's being able to explain that to them and telling them or pointing them in the right direction so that they can obtain that information. It's typically not through the law enforcement agency.
There are tons of exemptions under the Public Records Act. They deal with juvenile information. They deal with I've kind of called it the catch-all exception, where you can refuse to release somebody some information if you believe it could endanger the safety of a witness or a victim or someone who's involved in the case. So you can always use that as kind of a catch-all.
The exemptions are probably the most significant part of the Public Records Act as far as law enforcement and records and doing our job, because it's probably more significant what cannot be released as opposed to what can be released. We have an obligation to the citizens to protect the information that has to be protected from being released. And the exemptions just cover such a far-ranging area of information that we just have to be really careful. The citizens have a right to privacy under the California Constitution that just has to be protected.
Thing to remember with exemptions is every record that is produced is a public record, unless there is an exemption on it. There is an exemption on almost every one. There are exemptions on the exemptions. We kind of laugh in the records world at there is no black and white answer in records. It is all gray. Coming from the San Joaquin Valley, we call it's a Thule answer. It's not going to be black, it's not going to be white, it's going to be gray. And the Thule fog is about as gray as you get. The way to deal with exemptions is to absolutely stay current and know what is going on in the legislation as far as your laws go, because they do constantly change. Again, CLEARS has been a very valuable asset for us to use because we do have a strong interest in legislation. We have a legislative person that works for us and with us and keeps us on top of it.
Exemption is very critical because you have to know when there's an exemption in place that governs a specific record and whether or not it's available for release. For example, we have child abuse and elder abuse type cases that come in, and if you don't know that there's an exemption, you're going to release that record because it's a public record. So knowing that there's an exemption in place and following a specific process each and every time you get a Public Records Act request and being able to identify whether or not there's a specific statute that governs that above and beyond the Public Record Act is very important.
You can use the exemption of it's still under investigation and we haven't decided if there were child charges going to be filed or not. That's another exemption you can use from delaying the release of the information. There's just so many to go through, and you have to go through this process every time you get a subpoena, every time you get a request for records. You have to go through this step by step. You know, if you say yes here, then I go here. If you say no here, you go to the different step, that kind of a process.
Well, we certainly come across repeatedly with regards to child abuse specifically that quite often parents are under the impression that they have access to records with regards to child abuse cases. And just statutorily, that's not the case. There's really specific individuals who have access to child abuse reports. And parents, interestingly, are not listed as those individuals who have access. With regards to elder abuse, again, there's a statute that lists very specific individuals who have access to that. They just happen to be two of the types of reports that have very specific statutes that authorize their release. I think we've talked about how the Public Records Act has some gray areas, and you may have covered that with some other people that you've just talked to. Those just happen to be two very distinct areas that dictate who can have access to those types of reports.
Exemptions cover a variety of issues, from juvenile records to protecting the names of confidential informants. And, as pointed out, exemptions can be a foggy gray area, so staying current is essential. Exempted records include preliminary drafts, notes, or intra-agency memoranda not retained by the agency. Records pertaining to pending litigation to which the agency is a party until adjudicated or settled. Personnel, medical, or similar files, the disclosure of which constitutes an unwarranted invasion of personal privacy. Records of complaints to investigations conducted by or investigatory or security files compiled by, records of intelligence, information, or security procedures of any state or local police agency. There are also exceptions within the exemptions. For correctional, law enforcement, or licensing purposes, except state and local police agencies shall disclose names and addresses of persons involved in the incident or witnesses other than confidential informants to the incident, descriptions of any property involved, date, time, location, diagrams, statements of the parties, statements of witnesses other than confidential informants, fire, explosion, larceny, robbery, carjacking, vandalism, or vehicle theft. Exemptions continue after the incident moves to prosecution. District attorney is exempt when making a request of inspection of records of complaints to or investigations conducted by a local agency for licensing purposes under 6254F. Agencies shall allow inspections of copying of public record when requested by a district attorney. Disclosure to district attorney affects no change in status or record. Any crime or public offense that would constitute a misdemeanor or felony which results in injury to a resident of this state, unless the disclosure would endanger the safety of a witness or other person involved in the investigation, the disclosure would endanger the successful completion of the investigation, or the disclosure would endanger the successful completion of a related investigation. Nothing requires the agency to disclose that portion of those investigative files that reflect the analysis or conclusions of the investigating officer, including records, the disclosure of which is exempted or prohibited pursuant to federal or state law, including the provisions of the evidence code related to privilege. For example, juvenile information, child abuse reports, traffic reports, elder abuse records. As we will see in an upcoming segment on Corey, state summary criminal information and local summary criminal information both are featured in the exemption category, as are police officer personnel records.
What I can do is provide you with a list of phone numbers that you can get, and you can call them and get the information, okay?
All right.
That's what this is.
I need to get moving. Thanks, man.
Sir, excuse me, can you come back?
What?
Well, I need to look this over, so if you can just wait a minute till I'm done with this lady so I
I'm
can
kind of
ask you a
pressed for
couple
time.
questions. Well, I need to ask you some questions.
It's all
on this.
there.
No, I need to ask you some questions. You just wait a minute until I'm done with this lady.
Fine.
Thanks. Here's the paper, and I think you're going to need to call this number here.
This one, okay.
And they'll be able to help you out, okay?
Thank you.
Sure. Bye-bye.
No, it's all here.
Hi.
Fine.
Well, just looking this over really quick, like I noticed you're asking to see our records.
Yeah.
We're not going to let you back into the records right there.
What do you mean I can't look at your records? It's right there. I'm requesting them. Obviously, they've got to be available
Some
to
of the
me.
information is not releasable, like the reports may contain criminal history information, which some other things are not public record, and you can't have access to that. Okay.
Fine.
Also, looking on the second page here, I notice you're asking for some dispatch tapes and things.
Right, we need 3 years.
We only
worth,
keep
right?
those back 6 months, so
6
you're asking
months?
for like 3 years.
I only need 3 years.
Yeah, we're not going to be able to provide you with those. You're going to be able to get what we have for the last 6 months on this.
Okay, I can take the 6 months then.
We'll give you that. And I don't see a notice of consumer that they've been put on notice that you're trying to get their information.
Well, certainly they've been put on notice. They've been sued, so of course they've got
Well,
it.
I don't see any paperwork here indicating that you've mailed them anything,
So I
you've
need to get
notified
another-
them. So you need to have
another
that
form
notice
for
of
that.
consumer here.
Okay.
For their information.
Fine.
Okay. Also, I don't see a declaration attached to this.
Yeah, it's because I don't need one. I've already looked into that.
You do need a declaration form for this?
What
Okay.
law says that I need to have a declaration
What I'll
form?
do is I can provide you with a website, and you can go there and get that declaration when you come in to pay for this stuff, because we're not going to release it to you until you pay.
Okay, so I need to get you
Then
a
we'll
check
go ahead and give you the
and the form.
declaration. We'll be able to do it by this production date. I don't think that'll be a problem.
Okay, so the forms
just
won't
make
hold it
sure-
up?
No, the forms won't hold it up as long as you bring it in when you come in with a check,
Oh,
because we're
okay,
not going to
fine.
release any information to you until we get the pay from
Do you have those forms here, or do I have to get them online?
I don't have the forms, but what I can do is get you the website and you can get them online, okay?
Yeah, that'd be fine.
I'll write that down for you. And then we'll be able to,
Okay. So now, what are the forms again? It's the...
you need the notice of consumer form
Right,
for third parties who aren't
I don't think
involved
I
here.
need.
And then you also need the declaration form,
and the declaration.
and then you'll need a check. And we'll let you know once we produce everything how
When
much
you
it's
get
going to
everything
be.
there, you're going to give me a
Yeah,
call?
we'll give you a call
I'll
because
bring
your
you these
number's right
two
here on the
forms,
form. We'll let
bring
you know
you
how
these two
much the
forms
check
and
is
the
and the 2 forms.
Okay, wonderful.
Okay?
Thank you.
All right, thank you very much.
Subpoenas are a formal document, which is a formal public records request. They're not a court order. There are certain stipulations that a subpoena has to follow, very specific in the law. They have to include certain information. You have to have a certain amount of time that you're allowed to respond to the subpoena. If it's a third-party request, you have to have a notice to consumer. So the person accepting the subpoena needs to know what those parts of the subpoena are that are required in a subpoena.
I think the most difficult part is the ambiguity that subpoenas tend to have, because they frequently are not sure exactly what they're asking for. So we almost always have to make a phone call when we receive a subpoena to get clarification and to possibly ask for additional documentation if we don't have what we need. If it's not all in writing, we'll call and ask them to provide that and let them know that we can't proceed until we get that information.
Well, there's 2 types of subpoenas that we get in a record situation. There's a subpoena to produce records, copies of police reports, photographs, videotapes, and then there's a subpoena where they're requiring somebody's personal appearance in court to testify as an expert. And our role is to, when you get a subpoena, is you have a time limit. If it's there's 2 types: a criminal subpoena or a civil subpoena. In a civil subpoena, you have a time limit of about 15 days where you have time to respond and get the information. For the criminal subpoena, you only have 5 days. Criminal subpoena is for a criminal case where it's the state of California versus John Smith. And a civil subpoena is usually a divorce case, a child custody case, something like that, where 2 parties are suing each other. Normally, we either get the attorney, or in most cases, we don't get the attorney. We get either a discovery service or a processing server that they have hired for that attorney, and they come in and do the paperwork. They serve the paperwork on us. So usually they might not have the answer to some of the questions. So it's okay to accept the subpoena, and then at that point, whoever deals with the subpoena following through and reading it through needs to then contact the attorney and deal with them if there's some problems in regards to producing the records or they forgot to do something.
They're very intimidating because they look like an official court document that comes in from the court. And lots of times you'll have, the records clerk who's taking in a subpoena look at them and say, oh my God, we have to react. We have to get this information out. We give them everything that they're asking for. And actually, it's just a very simple reminder when you tell a records clerk is a subpoena is not a court order. It's not an official document. It's just a formal request. So sometimes when you take away that from it and just say it's not a court order, then they tend to relax and say, oh, okay. So now you look at it. And again, if you have a process in place that says, you take a subpoena in, you review it, you look to see if all the steps have been taken, if everything's in accordance with the subpoena process, and then go through and say, okay, what can I release, what can't I release?
We receive subpoenas daily. We have a large department, and we have a circus that comes to town, and several that come. This one particular circus, there was an incident that happened where someone was injured by either another party or by some animal or somebody in the circus. The subpoena just simply stated any and all incidents from this date to this date, which I believe was 7 or 8 days. And any and all incident could be someone's snow cone got spilled on someone, someone's wallet could have gotten stolen, they could have lost their wallet. It could have been any type of incident. Could have been a fight amongst two people that, had too much to drink. That's what we kind of call a fishing expedition on a subpoena. They want anything and everything without specifying what exactly it is they need. And it's very difficult to research those type of things.
Well, it could be right from the beginning. If the case is a criminal case in which your agency was the investigating agency, your agency requested the DA file charges against somebody, then an attorney shouldn't be serving a subpoena on you in regards to getting that information. The only way they should be getting it is through discovery. Sometimes you may get a civil subpoena served on you for information and maybe, say, a child custody proceeding where you have a police report, a case you did, maybe it's a domestic violence case. In that case, maybe you haven't sent it to the DA, and until the DA makes a filing decision, then you're going to have to hold off on giving that report out until the DA makes a decision whether they're going to file charges or not, because it's still under an active investigation.
But if an attorney chooses to bypass that process, then they will issue a subpoena to the agency. At that time, at least in our agency, we will contact the district attorney's office, let them know we've received the subpoena and how do they want us to move forward. We will find out from them if they want us to comply with the subpoena and provide them with the same information, or if they want to take the subpoena and take it before a judge and have the subpoena quashed.
Subpoenas requiring the production of documents is a subpoena ducis tecum. This subpoena, or SDT, is not a court order. It is a legal procedure to obtain certified copies of business records. The subpoena, however, cannot be ignored. Compliance is made by delivering or mailing a true, legible, durable copy of all records described to the clerk of the court in a separate enclosed wrapper, sealed and written on it the title of the action, name of the witness, and date of the subpoena. There are alternate ways to comply with the ducis tecum subpoena. Timing for compliance is dependent upon the nature of the action, including criminal case, 5 days after receipt of subpoena. Civil case, 15 days after receipt of subpoena. Fees are involved in complying with the subpoena. The time frame for compliance may be changed by agreement. If the district attorney's office does not wish to comply with the subpoena, they will file a motion to quash with the judge. The important things to remember about the ducis tecum subpoena are: always consult with city's legal counsel. Be timely. Gather all the records sought. Request clarification if necessary. Do not volunteer any documents not called for by the subpoena. If claiming exemption to production, be specific and complete. Restate the request verbatim. Notify the district attorney, criminal. Maintain response filed, and recover duplication costs.
Hi, can I help you?
Well, actually, I need to hire a babysitter. And, I was talking to my sister the other day, and she's just like, oh, you can't just hire anybody. You got to know something about them. And I didn't know what to do. And so can you, help me?
What is it that you would like me to do for you?
I have her name in here somewhere. And I know it's here somewhere. Let me just find it. And I was just wondering, they said that maybe like you could like put her in your computer and check and see if she's done any bad stuff.
Oh, I'm sorry, I can't do that for you.
Well, why not?
It's against certain laws and regulations. I can't give you that information.
But you know people do bad stuff.
Yes, I do realize people do bad stuff.
And
I
you can't tell me
give
if
you
she's
that.
done bad stuff before I hire her?
No, I can't give you that
Why
information.
not?
Because the law says that you're not entitled to that information.
But do you know what bad things these people do? I mean, have you watched the TV shows? I mean, they shake babies and stuff.
Yes. I just can't give you that information.
So how do I like keep my little kids safe without knowing if they've done something bad like that?
You know, an option for you may be to go through a agency.
Like what kind of agency?
Well,
Because this is like a police agency, right? And you like keep records, right?
A babysitting agency who can get that information for you because they have contracts with the state that they are able to get that kind of information.
So I would just call them up?
Yes.
And where would I find an agency like that?
You can find them in the phone book.
Really?
Mm-hmm.
And they would be able to tell me that?
Yes.
Wow. Well, that's just awesome. Well, thank you so much for your help. Thank you so much. Have
You're
a great
welcome.
day.
You too. Good morning. Can I help you?
Yeah, I'm wondering if I can get some information from you. I'm really concerned about my daughter. She's going with this guy who's much older than she is.
Mm-hmm.
And, you know, are you a parent?
No, I'm not.
I just, sometimes you just get this feeling about some people that they're around, they're not the right people. And I just get a bad feeling about this guy. I was wondering if I can get some information on him from you guys.
I'm sorry, I can't give you that kind of information.
Why? Why can't I get any information on him? Why is...
Per law, that's confidential information. He's the only one that could get that type of information. If he did have something, you don't even know if he does have.
So if he has like a criminal record, there's no way that I can find that out? Or if he's like a sex offender or something, I can't get any?
You can find out, you can go on Megan's Law and run his name on that system, but other than that, there's nothing that I can give you.
So the Megan's Law. So if I go there, I can get all kinds of information about him?
Only if he's a registered sex offender.
But what if he's not a registered sex offender? What if he's, somebody who's a burglar? Or, like I said, he's just so much older than she is.
No, I
and
do
he's
understand.
really kind of controlling and...
Yes, I understand your concern, but I can't give you that information per state law.
Well, I can't even get any information about him at all?
No.
Is there anywhere I can go? You understand, I'm really worried about my daughter.
I do understand, but no, there's nowhere that you could go to get that information.
I can't get anything on this guy? I can't learn, I can't learn anything if he's ever been convicted anywhere or anything, or I can't see if he's been arrested here in our city or, been arrested somewhere in California before?
No, you can't get that information. I'm sorry.
There's no one that you can refer me to or anywhere I can go to get something like that? You sure?
You could go to the court if you wanted to find out about conviction information, but I can't give you any arrest information. We have people who come into the stations quite frequently who want to get information on their neighbors, their daughter's boyfriends, their babysitters. They want arrest information. They want all this kind of information that they think that they're entitled to, and they see like on TV or that people get this information, and so they should be entitled to it because everything is open and public. And we have to explain to them that no, there are laws that stipulate who can receive certain information, who can't, and we call it our CORI, which is our Criminal Offender Records Index. And we have basically two different kinds of CORI. You have your local CORI, which is records that are held by the agency, and then you have your state CORI, which is a compilation of all agencies' records that are sent to the Department of Justice. And all that information is confidential. And the only people that can receive that information is the individual themselves, or there are certain agencies and organizations that are entitled to that information, especially organizations that deal with children. They are allowed to receive that information.
CORI is Criminal Offender Record Information. It basically has different levels. You have local CORI, you have state CORI, and you have federal CORI. Your local CORI would be if you're arrested in your local county and that information is available in that county, that's your criminal offender record information for that county, okay? That information is also transmitted up to the state. So when people think about their rap sheet. I have a rap sheet because I got arrested in San Francisco. That rap sheet is a state rap sheet, and the information on that rap sheet is considered CORI. And then you also have CORI at a federal level, where certain information is forwarded on to the Federal Bureau of Investigations, and it goes on your federal rap sheet per se. But most of the time when you talk about a rap sheet, you're usually talking at a state level. And the information on a state rap sheet is typically not releasable as it is.
CORI is the criminal offender record information, and access is limited. A local agency shall furnish local summary criminal history information to any of the following: courts, peace officers, district attorneys, prosecuting city attorneys, probation officers, parole officers, public defenders in certain circumstances, the subject of the information upon applications, health officers, and supervising correctional officers. The general public does not have access to CORI files. Any employee who furnishes a record of information from a record not authorized by law is committing a misdemeanor. When releasing CORI information, a release log is required. The log should include requester's name and agency, date of release, type of CORI released, how data was transmitted, telephone, letter, in person, name of person releasing CORI. Out-of-state CORI is obtained through NLLETS. The log must be maintained for 3 years. Individuals have the right to request information on themselves.
Now, if someone wants to get their own record, they would go to if they want to get their own local, they would go to the agency, provide identification, and then the agency would provide them a copy of their record. If an individual wants to get a state record, they would have to contact the Department of Justice, and one way to do that is on their website. You get a form, you have to submit fingerprints, and then the Department of Justice would send them their record. Hi, can I help you?
Hey, well, you know, I'm trying to start my life over again, and I need to, well, you know, I've been in some trouble in this area, and I kind of need to know what kind of trouble I've been in.
So you would like to get a copy of your record, your arrest record?
Yeah.
So you have been arrested?
Yes.
Okay, and you want a copy from us of your arrest record?
Yeah, because I kind of need to know, because when I get a new job, they're going to ask, and I need to know what they can find out.
Okay, well, I can give you a copy of your arrest record from River City. I just need for you to show me your identification and...
Oh, I don't have my ID with me. Can I just give you my name and maybe...
No, you're going to have to come back and show me your identification, and then I can give you a copy of your
But my name is
record.
Maria Elena Alvarez, and you can't just check for me and give me a...
No, I have to have some kind of identification from you, because you could come in here and tell me you were anyone, and so I need to have identification.
Okay, so when I come back, can you tell me, like, I've been in trouble in other places. So
in other cities?
Is it everything?
The only
you can
thing
show me everything?
The only thing I can show you is from the city, but you can get other information through the whole state if you contact...
So I've been in prison. Where do I go?
You could contact the Department of Justice. If you have access to a website, you can look at their website and get the information, or I can give you...
No, es bueno. I want to do it here.
Okay. I can give you a form. You can fill out the form, which you will have to mail to the Department of Justice, and they'll send you back information
and
tell you...
mail it to my house?
Mm-hmm. And they'll mail it back to you and tell you what you need to do.
Okay.
Okay?
Okay.
Okay. So you're going to come back here with your identification.
Oh, you can't give me the form now?
I can give you that form now. But as far as your information for this city, you have to come back with your identification, okay?
Bueno. Okay, gracias.
Okay, you're very welcome.
Hi.
Hi, can I help you?
I need a letter.
What type of letter?
A clearance letter. I need it for immigration. I have an appointment for an interview.
Okay, and have you ever been arrested or contacted by a police department?
No.
Okay, what I'm going to need to have you do is fill out a form, And when you're done completing that form, I'll also need to see your driver's license, and we also charge $20, so either cash or check would be fine. Okay?
Okay.
Okay, so if you want to go ahead and take a seat and fill that out, and just let me know when you're done.
Thank you.
Uh-huh. Hi, you all done?
Yes.
Okay. Okay, that looks good. And I just need, okay, that's great. And then your photo ID? Great. If you just want to go ahead and take a seat, and I'll let you know when we're done.
Thank you.
Typically, they're looking for a copy of their arrest information for employment purposes, occasionally for housing. Even though employers are not supposed to run a background check for somebody unless it's for law enforcement reasons, they will frequently request a good conduct letter that shows the person hasn't been in trouble. So when they do that, we will run a local criminal history record. We don't run it at the state or federal level, but we'll look locally and see. And that's something that's allowed by the county, in my case, San Diego.
It's very important to be vigilant of CORI issues. The records technicians maintain a log of CORI access. They maintain a log of CORI release. And it's very important that that information is given to the proper individuals requesting that, and not given to the nosy neighbor next door wanting information on their neighbor. That information is strictly for you, not for anybody else, or for law enforcement purposes only. CORI has been droned into everybody's minds and how misuse of CORI and the prosecution of CORI that can occur. It is something that in our department, we sign a release every year at evaluation time for misuse of CORI, and it does warn them on what would happen to them if they did misuse the system.
Once the application is filled out and fees are paid, the records personnel would check their local records management system for any contacts or arrests with that person. If there are any related reports or contacts, personnel would then check further by either pulling the case file or checking the automated case management system for the status and/or disposition of the case. If there is an arrest associated, personnel then need to check for a final disposition. If the person has been arrested and convicted, then a letter is drafted to indicate that the person does not meet the necessary requirements for a clearance letter. However, if there are no convictions, a clearance letter is prepared and provided to the requester. Ms. Driver? Hi there. Here's your license back. And here's a receipt for the $20. And here's your clearance letter. Everything looks good, and that's what you can show to the immigration when you show up for your interview.
Thank you.
You're welcome. Have a good day.
You too.
Good morning. Hey, Delphine, how's it going?
Hi, Alan. How are you?
Oh, not too bad. Just hanging out a little bit today.
So how are things going with you?
Good, good. How's Jim?
He's doing good.
You
really
guys,
good.
you guys got the boat going this year?
Almost. We've almost got it.
Head out to the river yet?
Not yet.
No.
So you want to go with us when we do?
Oh yeah, we had a great time last year. I had a really good time.
Yeah, it was fun. It was fun. How's the dog?
Oh, he's good. We just got him retired a couple of months ago, and so he's at home resting. He served his time, so
well,
he's
good
done.
For him.
Hey, I don't know if you remember my sister Allison and her husband Gary.
Yes, I do. Yeah,
they came with us out to the river last year.
Mm-hmm.
Well, I guess over the weekend he beat her up a little bit. And, and Holmes went out there and took a report. I was wondering if you could pull that report for me and let me take a look at it.
Oh, well, Alan, are you investigating it?
No, I just want to see what what he documented on there, and just trying to help my sister out.
Oh, well, you know that I can't do that. You're not really entitled to the report.
Okay, well, we got that out of the way. Can you give me it?
You know that there's a lot of things that cover release of information. There's the Public Records Act, there's CORI as to who can and can't receive information, and there's our policies and procedures. And
yeah, I get all that, but River City gives me a gun and a badge, and lets me go out there and arrest people based on my trustworthiness and knowledge, and I can't get a copy of this report.
Well, I totally understand that, but they also give me a responsibility to abide by the policies and procedures, and you know that that's something that we all have to abide by, and I just can't release that to you.
Yeah, well, I just figured since we were friends, maybe you could help me out, but...
No, I'm sorry, Alan. I just can't go that.
Okay, well, thanks anyway.
Sorry.
So the most difficult time that we have as records clerks or communications dispatchers is telling an officer, if you don't have the need to know this information, then you don't have the right to know it. So it's providing training to the department on when can you obtain this information, how can you obtain it, and when you can have it. The other big piece of it is typically you have an officer in the field, and when they're requesting this information, it's because they're actually contacting this person. They're out in the field and they're requesting this information over the radio. Well, it's not public information, and the Department of Justice strictly prohibits us from broadcasting criminal history information over the radio.
You process accident reports and you send a copy to Sacramento, and that's how an accident report gets on a person's driving record. Well, one of our clerks observed a sergeant remove one of the accident reports that were to go to the Sacramento, and come to find out his son was involved in an accident, and that's the report that he removed so that it wouldn't be sent to Sacramento. And we did an internal investigation. It was very difficult for the clerks to turn him in because he was a well-liked sergeant, but that is definitely against policies, procedures, and law, and he was prosecuted as a criminal act and convicted and lost his job. So it's very important that we abide by the laws, follow policies and procedures, because you can be prosecuted in court.
I think the most important thing we need to avoid is trying to give somebody something just because they want it. The most important thing is to remember that we do have to abide by the law, and then we can explain that to somebody so that they know it is applicable across the board. The Public Records Act does not differentiate that because somebody has a certain position or a certain job that they are entitled to more information than somebody who doesn't hold that position. So it is applicable across the board in how the information is given and who receives the information.
To educate officers as to what the Public Records Act is, we have a directive which is very specific about that, quotes the law and what is part of the Public Records Act and what people are entitled to. We also have directives that explain to the officers the procedures to follow. So if in doubt, that's where the officers need to go to find out that information.
So it's very difficult to communicate to this officer who's out in the field who says, I don't care, I want the information. So it's really important to actually have a policy in place in your agency that talks about the need to know, the right to know. If you're out in the field, how do you go about requesting the information? How does a dispatcher or records clerk go about providing the information so that we're in compliance with the Department of Justice?
Just because you're law enforcement and you have the right to know doesn't necessarily mean you have the need to know it. If you are not actively investigating a crime against Michael Jackson, you can't just arbitrarily go into a computer database and run Michael Jackson because you're a member of law enforcement. You don't have the need to know. You're not in the middle of an investigation. I've had staff who have had a car parked out on their street for weeks, wondered who the car belonged to, come in, decided they were going to run the license plate on that car to see who it belonged to. In one instance, it came back as stolen. And they thought, oh, wow, I just found a stolen vehicle. We can recover it. So they called the communications center so they could send a deputy out and recover the stolen vehicle. Sounds like a perfectly innocent thing to do, but the bottom line is, yes, she had the right to know because she's law enforcement, but she wasn't actively investigating that car, so she didn't have the need to know. Therefore, her use of a computer database was actually a case of misuse, and she had to be written up for it. She was not allowed to run that. She was not investigating that car. If she was a patrol officer who in the course of his duties was wondering why this car has been parked in front of, this empty lot for the last, 3 weeks and wanted to check and see if it was stolen, then that officer has the right to run that information. But one of my staff in records, just on her way to work notices this car day after day. That's not a need to know.
Hi, can I help you?
Yeah, I'd like to get an accident report.
Okay, when did the accident happen?
Happened this morning.
Oh, just today?
Yeah.
Unfortunately, it's a little too soon for you to come in and request that report.
There's no chance I'll be here.
Okay,
No
look, I'm
chance
sorry. I have
today.
a very important issue to address to her. Do you mind?
Ma'am, I'm
Okay.
sorry. I'm right
No,
in the
no,
middle of helping him.
There's something very important that
Please,
I
it's
need
only
to get.
going to be just
I'm
a
from
few
the mayor's
minutes.
office, and I need to
I
speak
understand
with
that,
you.
but if you'd let me just finish with him. Thank you. Like I said, it probably won't be available for about 10 working days, so if you want to call us back or come on in and check back, and we can give you that information then.
Okay.
Okay?
Thanks.
Thank you.
All right, thank you. I'm sorry.
Can I help you?
I'm from the mayor's office. I'm coming here to get an
Okay.
incident report.
Okay.
He said it's very important. He needs it immediately. Tonight there's a city council meeting.
Okay, what type of report is it?
It's a citizen who was involved in an incident where the police were called in. The citizen
Okay,
always
so
goes to the city council
The
meetings.
mayor
He's
was
always
not involved in
harassing
this?
Of course he was not involved in it.
Okay. The mayor's not going to be able to get a copy of this report then if he wasn't involved.
No, you don't understand. The mayor sent me here to get
I
this
understand
information.
that.
I need the information. I need to leave with it and
I'm
return
sure you
with
do.
it.
I understand
The citizen
that.
is always at the city council meetings,
Okay.
and he's always challenging the mayor. And the
Okay,
mayor.
let me explain to you. Just one second, okay, please? I understand that you need this, but let me explain to you. Under the Public Records Act, an elected official is not able to obtain a copy of a report any more easily than the general public.
Okay, but the mayor is confident that
I
it was
understand
not
that.
handled properly, and he sent me here
You
to
know,
retrieve this information
I'm not
about
going to be able
the
to give that to
citizen.
you.
Is there someone else above you that I can talk to?
No, at this time there isn't.
And what is your name?
My name is Lisa.
Thanks, Lisa.
You're welcome.
I've had the head of agencies that I've worked for come to me and say, hey, I need you to run this. And I've had to say, no, I'm sorry. And they'll kind of look at me like, don't you know who I am? And my response is, I'm sorry. The laws are very strict. My job would be on the line. So whether you're the chief of police, the sheriff, the mayor, head of city council, city attorney, it doesn't matter. Who you are doesn't automatically give you access. You have to have the right to know, and you have to have the need to know. And every transaction that my staff runs in a computer database, they're required to put in a case number if it's a crime case, a booking number if it has to do with someone who's been arrested or is incarcerated.
People in usually higher positions believe that they should be entitled to more than others. They don't. I don't know if they don't understand that we follow the law. It's not just the record supervisor's manager discretion that they make these decisions. There is laws and policies, and there are people, though, that feel that they should be entitled to receive anything they want. That either if they are law enforcement or politicians, mayors, they feel like that they should be entitled to that information, whereas they all fall under the classification as the public.
We have had people call our office who are members of a board of supervisor, panel, city council, spouses of those individuals who have tried to use that position to get information that they might not be entitled to.
Sometimes people in the public sector believe they have a wider access to information than the normal citizenry, and that's not correct. They have no more right to information than does the general public.
There are some people like that. Just from personal experience, I know that maybe they're an official or like I know one case, so a difficult situation for me is one time we had an accident involving some small children being injured on the way to school. And one of our city council people called in and wanted to get the address of the children. They were 8, 9, 10 years old and want to get the address because they want to send cards and flowers. And I was the one who had to tell her, well, it's not public information. I can't give it to you. You're not entitled to any more information than the average citizen off the street was. So just because they're the press or a mayor or city council or whatever, they're not entitled to more access than anybody else.
If an inadvertent release of quarry is made, you can be held criminally liable. You can also be held punitive damages against yourself.
If information is accidentally released, then that's something that we deal with as an agency, and that's something that everybody involved with the release of information needs to be aware of. So it should be, again, just somewhere in the, as you put it, mental checklist for anyone that has to be involved with the release of information. I think they think about it peripherally, may not immediately be on the forefront. However, it should be somewhere in their mental checklist, because if we release information inappropriately, liability is certainly out there. Certainly if there is intent to release information inappropriately, there is room for liability again, both on a civil level and on a criminal level. Again, that's with intent. There have been cases of it in terms of personal civil liability, and again, I think that's where you start to get involved with the intent question and the intent to release information.
If the information is released when it should not have been released, that information then becomes a public record and is available to everybody. And if that happens, then that can open up an agency to problems of liability.
It's huge. Liability is a big term that we always use when every time you go to process typically something new or something you've never seen before. You almost always think, oh my God, am I going to be liable? What if I do something wrong? What's going to happen to me? What's going to happen to the department? And that really comes into play when you're releasing information in a couple of ways. Number one, if you release information you shouldn't have released, it now becomes a public record, so it's releasable to anyone. And if you happen to be the victim of that record that was released and you find out about it and you think, hey, that never should have been released, now the city's liable for a lawsuit, you're liable for a civil suit for having released that information. On the flip side of that, you sometimes have the employee that thinks they can give that information out because they have access to it and knowingly and willingly give it out when they know they aren't supposed to. Again, liability for the city, liability for the employee. The only thing you can do is maybe notify, I would definitely notify a supervisor or manager or the chief to let them know, hey, this was released accidentally and this could come back to haunt us. Maybe notify the city attorney so that everybody at least has a heads up on the situation.
Media requests are referred to the public information officer for the most part. If we are able to provide the media with information, simple information like calls for service, the daily incident log, something like that, we will provide that.
Our PIOs respond to the media in terms of interviews, and they handle our press releases for for our more high profile cases. As far as releasing the reports, though, that comes from our records unit.
I think as an agency, there should definitely be a point of contact for the media so that you only have one person kind of fielding the information, knowing what's coming in, what's going out. Typically, I would encourage that point of contact, or I don't know what they call them, PIO, Public Information Officer, to understand the Public Records Act. Lots of times you will have them put together a press release with information that goes out that never maybe should have gone out in violation of the Public Records Act. So having a good ongoing communication with that PIO, knowing what they're putting out, having them tell you when they're going to put something out, so when the calls start coming in, you have something to reference, you have something to fax, you have something to send out, so not more information is getting out than should be, and it's consistent information.
And then if it's a high-profile case, we may give them photos, or, we had a profile case where they wanted, we had a sting in regards to prostitution, and everybody wanted the photos of the people that they arrested, and we ended up giving all that to the media. So
if you're straight with them, it doesn't stop them from asking you, but they realize that you are being honest with them and doing what is right and abiding by the law.
The law is very specific regarding who has access to what information. Any deviation from the law, even well-intended, can result in liability, personally and for the department.
Sheriff's Office Records, this is Kathy.
Hi, Kathy. This is Karen Thomas from Simi Valley Police Department. I met you a couple months ago at the CLEARS conference in San Luis Obispo, and you said if I ever had any questions, I could call you.
Hi, Karen. I do remember you from the CLEARS conference. How are you doing?
I'm good. How are you doing?
Good. What can I help you with?
Well, I do have a question, and it's just a little unusual. So I've received a letter from a court-appointed evaluator who's requesting copies of a child abuse report. And they've sent me waivers signed by both the mother and the father of the 5-year-old child abuse victim. So do you think that the requester is entitled to this information?
Well, I think I have a question to ask you first. What are the specific charges of this report?
Well, the report has been written only on the state abuse child reporting form, and the circumstances are listed simply as suspicious circumstances.
Okay, so no criminal charges then have been on this report. And is there any narrative that goes with this report?
No, there's no other narrative on it, and I don't believe that it's going to go any further.
Okay, because since there are no criminal charges on this report, then there is no covering of the exemptions in the Public Records Act. And as long as you don't have anything contradictory in your report, you should be safe from any liable issues, and it would be okay to release it.
Okay, so let me ask you this question. What if the suspected abuser, who is the father, by the way, wanted a copy of the report? Could I release it to him, and do you see any potential liability for us?
Right, that is correct. And this particular child that you're talking about, this juvenile, is not a suspect in this report. And even though it does seem a little strange that the father, who may be a suspect, has signed a waiver, it would still be okay for him to go ahead and have a copy of this report, should that situation occur that he asks for a copy after you release it to the evaluator.
Okay, and as we've been talking about it, I think it would probably also be prudent at this point to review the county T&G order. I think that it does say that representatives of a victim can get copies of the report.
As long as you review your agency's policy and you're not in contradiction with that, then you should be free from liability if you go ahead and release this report.
Okay, perfect. Thank you so much.
Oh, you're welcome. Talk to you again. Bye.
All righty. Bye-bye.
Well, we are a very close-knit community. There are, 58 sheriff's departments and, 300 or 400 police departments. And so there's a very small number of us. And we try to communicate within our areas and within the state, because we all face the same kind of problems. We'll have an issue might come up in Southern California that we dealt with in Northern California. It's a very integral part. I've been doing records manager for 6 years, and it's great for me to have people that I can call around the state and kind of use as a sounding board, saying this is what I'm thinking, but do you agree with that, or should I be taking a kind of different look at it, and give you their opinion. And it really helps to have that sounding board you can go to, say, okay, yeah, I did it right, that's how I was thinking I was going to respond to this, or I didn't even think of that, I didn't even look at that code. So, and it helps to change. And then we build some very strong friendships also through that. Somebody new, to be successful, I think the most important thing is know what your agency's policies and procedures are to release information. Know what your agency says and follow those policies. If you go to some training and learn something different, maybe you should look at changing those. But as long as you know what those policies are and follow those policies, that's the biggest thing that's going to keep you out of trouble.
Well, if you have a question, it's absolutely critical that you go and you make sure that you're providing the right information to somebody, so that you are not just guessing about the information that you're putting out. So if I'm someone that's unfamiliar and I'm kind of a new person, I'm going to go and I'm going to ask an experienced coworker. If they don't really know the answer, it's absolutely critical that they go to the supervisor to check the facts on it. If they don't know, then they've got to go to the manager of the unit. If they don't know, again, confer with the city attorney, with your county council, because you absolutely have to know that whatever the law or the statute is that dictates the information that you're about to provide, it absolutely has to be checked before you're going to release the information or make the decision to not release the information. You just have to know what you're doing.
I think one of the most important things that anyone in law enforcement can have is a sense of where to go to get the information that you need. Whether it's a coworker, a supervisor, going on the internet and looking up the laws for the state of California, whether it's being a member of an organization such as CLEARS, the California Law Enforcement Association of Record Supervisors, where you can meet with other people in other agencies throughout the state and network ideas.
In California, one way to stay in touch with other record technicians and network is through the California Law Enforcement Association of Record Supervisors, or CLEARS. The organization was formed to help train and educate record supervisors from law enforcement agencies throughout the state. These agencies include, but are not limited to, county sheriff's departments, police agencies, district attorney's offices, state agencies, and local court personnel. The goal of CLEARS is to provide legal updates and to create a network of resources to provide members with the latest information available.
CLEARS is a lifesaver for a record supervisor manager, especially a new supervisor, because it's an organization that encompasses all the agencies within the state of California of record supervisors and managers, and you network with these people. You can contact them, you can talk to them, you can ask them how they've dealt with certain situations. I know in my agency, in my county, we are very strong networking. We email each other, we talk to each other constantly.
I was very fortunate when I first came to the sheriff's office to be told about CLEARS, and I was told that if I didn't belong to any other organization throughout my career, that CLEARS would be the organization to join. I have found it to be such a wealth of information. There is training on a regular basis, monthly basis for many of the chapters. You can attend other chapter meetings even if you belong to a different chapter. We have our annual training conference every year that is just superbly organized, put on with such a wide variety of training. And the networking that has taken place throughout CLEARS has just been wonderful.
People should absolutely be members of CLEARS for this reason. When I first became a records manager, and I was not always in records, even though I've been in support services for 33 years, when I did become a record supervisor or manager, it's very intimidating because you have all of these statutes that you absolutely must follow. And the only way that I was able to grasp that whole situation was by networking with other records supervisors and or managers. And the only way that I was able to do that was through CLEARS. My closest friends are CLEARS members, just because I know that they speak the same language, and I can always refer questions to them. Even though I may know the answer, you always need that backup to make sure that you're correct.
CLEARS is a fantastic resource. CLEARS is a great group. It's a great organization of people. They have a great website that has training classes listed on there. They have job opportunities that are listed, so they have contact information. This just a great group of people.
It's hard to stay on top of it all. CLEARS has been a lifesaver in that respect, in that we have each other that we can contact to give each other support and make sure we're giving the right answer on a question or on a release. Just to make sure that we have that right answer going.
The California Public Records Act is a vital part of the interchange between law enforcement, government agencies, the judicial process, and the public. It is a complex document which requires training and a continuous process of updating an individual study to understand. Remaining current with CPRA specifics and legal requirements is an essential job of the members of the Records Department and the field personnel of any law enforcement agency. For more information on CPRA training, contact the California Commission on Peace Officer Standards and Training. For Post, I'm Marcella Lee.
After 20 years in this business, what do I wish I knew when I first walked in? I think more than anything, it's just the realization that everybody's a human being, whether they are have a rap sheet a mile long, or it's the first time they got picked up on a DUI. They're still a human being. They still deserve to be treated with the utmost respect. And above all, have a sense of humor. You just have to have a sense of humor in this business because you're dealing with people at all levels.
Hang in there. It gets better over time.
We've saved a lot of chiefs, sheriffs over the years with just having the knowledge of knowing what to do or what not to do in certain circumstances to keep your department out of hot water, out of court.
I think it can be fulfilling knowing that you're helping someone out. And for the most part, we do help people on a day-to-day basis. Whether it's giving them the information or pointing them in the right direction, I think we do our best to get them what they want, get them what they need. I wish I could know everything walking in the door, and you can't. And sometimes it's actually knowing that, it takes a while to learn all of this information, and 15 years down the road, you're still not going to know it all. And it's being comfortable with that, but knowing, I guess, that you can go to someone or somewhere to get the answer.
You look like you're a little bit afraid here. You look a little afraid here. You really need this.
Oh, sorry.
Rolling. Wait for action. We already have one of these. Get over here. Listen to me. Okay.
Okay.
Just you gotta just
Sorry.
Hey, buddy, you caught her with the shit that time.